Pete, how you doing today?
I'm doing great, Steve, and you?
Doing good too. We're going to talk today about slip and fall cases. Everybody has tripped and fell and stumbled and been hurt and all that, but there's only a special kind of case where under the law people can recover damages for.
Well, Steve, just because somebody falls on someone else's property doesn't necessarily make the property owner responsible. Hey, I fell on somebody's property, I want to file a claim. You must show that the property was defective, that there was a defect of the property, and that the defect was substantial, not just a little small thing or a step that they tripped on or a rise in a curb. It's got to be something really substantial.
So if I'm walking down the street wearing sandals, I trip over a thing that's about an inch high, and it may not be great, but it did cause me to trip. Can I collect against that property owner?
No, I would submit that you really couldn't. It's such an inconsequential defect. Every piece of property around the country, especially in Westchester, Chester County, they have defective sidewalks. When I say defective, there's minor defects. It's only when it's a substantial or major defect. And I'd say in that situation, at least a couple inches or so.
Now, what about that situation, Pete? Let's say you're in a store. We normally see it in a store, normally in a food store for some reason. There'll be something on the floor that was spilled there. Is that a good case?
Sometimes it could be, sometimes not. You have to prove notice. The property owner has to either have been aware that there was a defect of the property and had the time to correct the defect.
Now, you always give a good example I've heard you give to clients about a grape in a store. Tell us about
Yeah,
that.
perfect example. Shopping in a supermarket, they come around the corner and there's grapes that were squished on the floor, go down and break their hip. Say, for example, a young kid came around the corner a minute before and bumped into the bin and knocked the grapes on the floor. I submit that they're not going to be held responsible.
My client slipped on milk or slipped on a grape, and we don't know if that was there 20 seconds before or an hour before.
Are the records kept? Are there videos?
And you hear the owner of the store come over and say, hey, I told you to clean that up 20 minutes ago and you didn't. That's a good case.
Oh, absolutely. And I had a case where somebody came out as a grocery store and the owner had moved in some supplies and left the wooden pallets right outside the door, and they actually happened to be the same color or blended into the sidewalk. And the gentleman came around the corner, caught his right foot, went down, 2 to 3 operations trying to get better. Was that a case? I suspect that, yeah. He knew the pallets were there. The owner put the pallets there. They shouldn't have been in the position where they were.
And my most interesting case is there was a display in a store, a display going down the steps of little trinkets, and it was mesmerizing to see it. Well, you don't put it down the steps because people normally know their steps there, but they're looking at the display. Down the steps they went. We get a lot of calls in the wintertime. I went outside and I slipped in a parking lot somewhere. Do I have a case?
Probably not if it's immediately after the snowstorm, because there's a duty to clean up walks, make them reasonably safe, not completely safe, and they have a certain amount of time to do it. Again, it's that sort of that notice issue. But a lot of statutes in Pennsylvania, a lot of local ordinances give the property owner 24 hours or so to clean it up.
It's all what's reasonable.
That's right. All boils down to reasonableness.